Good afternoon, everyone. Sorry for the slight delay. We had a couple of connection problems that we just had to resolve, but everything seems to be now okay, and we have our speaker, our guest, in the cafe. So welcome to this EOcafe. Remember just a quick reminder for anyone who doesn't, the rules. Please keep your microphones off unless I ask you to join in. Very welcome to keep your cameras on. And if you have any questions, please just pop them into the chat so that I can see them coming up. And in general, unless the question has been addressed, I would ask you to join us and to put the question directly. So I think that's all quite clear. Today we're returning to the subject of AI. We've something we've talked about before. We've looked at the technology and the possible impact on our sector, but primarily from a technological perspective. We've also considered some of the social implications, societal implications, but they're really only in passing. And today we want to dig into the regulatory framework, which is slowly taking shape, as we'll hear about. And so to discuss this, I'm pleased to welcome an expert from the legal profession, Matthias Lachenmann. Matthias is a lawyer at BHO Legal, who are an Ersk member and have been for some years. BHO offer legal services, so if any of you are looking for any legal advice, you can always get in contact with them. But hello, Matthias. You're still on mute at the moment, but if you could just perhaps say a few words about yourself, customarily, rather than reading out one of these sort of short CVs. I prefer to ask you just to introduce yourself directly and say, your background and where you come from and your interests, just so that people know you a bit.
Sure. Thank you, Geoff. So I'm happy to be here. So I'm a lawyer for more than 10 years. I was working in a law firm in Bonn for some years, but now I'm working at BHO Legal for 5 years as a partner, and mostly with a focus on data protection and privacy. But of course, privacy relates to AI, and therefore for several years, AI was one of my topics. And besides that, I'm publishing quite some works. You can see it behind me. Some of the books were published, and that has some words for me.
Right. Okay. Thanks. And we also have Ingo Baumann on the call, who in the cafe, I should say, who many of you will know has been around for some time with BHO Legal. So I imagine we all have stories of how AI is either improving our lives or businesses, and also how it is threatening them. It's particularly relevant in this year of elections. It really is a stress test on our democracies and the institutions that uphold them. And I think we all hope that they will succeed. I just, this week, I guess you've probably heard the Google, 12 months ago, Google released a competitor to OpenAI, to ChatGPT, which they quickly withdrew from the market because it was creating a lot of problems. And last week, I think it was, they released a new version of an AI tool called Gemini. But they've already pulled that from the market as well, because it was falling foul of some of the restrictions they'd put upon it. So as if you, for instance, asked it to produce a picture of a medieval king of France or England, you got a Native American dressed up as a medieval king. If you asked it to draw a comparison between Hitler and Elon Musk, it came back, this is a very difficult question to answer. Elon Musk has made a lot of very bad tweets, but then Hitler did kill many millions of people. So some of the moral boundaries that they were trying to build into it had gone a bit astray, and shows the problems with all the resources they had to throw at this, the problems of ensuring that these tools behave correctly. Closer to home, most companies are looking at how AI technology can help them in their business. And we noted in an earlier EOcafe how it seems to be very well suited for the interpretation of large volumes of data, which of course most of the Earth members are dealing with. We consider some of the potential benefits and pitfalls in the previous discussions, such as how do we maintain confidence in the integrity and the quality of our product, trustworthy, as I was just discussing with Ingo earlier. And of course, it's not just us, others are looking at the use of AI, and not all the applications are as benign. The examples I've just given. Deepfake audio visual recordings are becoming quite scary. And unfortunately, maybe AI has its own salvation by being able to monitor and judge where AI, but where's this all going to lead? And unfortunately, it's an uneven fight with those on the bad side of things, less constrained by the use of the technology than those on the good side. So a lot of potential to bring economic benefit, but a lot of potential to bring disruption. In consequence, regulation of AI is, I think, absolutely necessary. And the EU has already started to discuss this and even to promote an AI Act. And that's where we are today, talking about where the Union has got to, or the Commission primarily has got to, with the discussion around the AI Act. Parliament have reacted, so there's already quite a lot going on. But let's just wind back, look at the objectives, or at least what the objectives of such an act would be and what it's likely to cover. And then we'll go on to talk about the implications for industry and for our sector. But Matthias, perhaps you could just kick off by telling us what the EC or the EU is trying to do and trying to achieve.
Yeah, thank you very much. So for the start, regarding the AI Act, I think it makes sense to stress that the AI Act is not something like the GDPR. So I think everybody is talking about the GDPR in the last years. So even if you don't have anything to do with data protection, everybody knows GDPR, and most people hate it. I don't hate it, but whatever. So the AI Act is not like a GDPR, that it's applicable to basically everything regarding AI, but actually it's focusing on high-risk AI. And it's focusing on some certain cases of AI. So of course, like the general purpose AI models, like the open AI products, that is something that will be covered. And there will be some prohibited AI. That was also a political discussion, what to allow and what to forbid in general. So there were a lot of discussions like on biometric identification, which is now very limited or forbidden in most cases. So that is some of the area that is regarded by the AI Act. The most important thing will be the so-called high-risk AI, and there are some definitions. I think we will get into that later. But so as a start, I think it's important to realize that the most important things regarding the AI Act evolves around high-risk AI. So maybe 80% of the AI that every company uses is not afflicted by the AI Act. There are only some very few rules on that. So basically, it's saying for every AI you need to ensure AI literacy. So basically, have some information for all the employees to inform them about AI and the risks. But that is only some very few obligations for all companies, and the most of the obligations evolve around the high risk AI, and so I think of course it makes sense to look deeper into it also regarding the space industry.
So I guess the obvious question from there is what is high risk AI? what is understood to be covered by the Act?
Yeah. So if I would recommend that I show one slide or maybe two slides
Please.
to give some more information or to help with the understanding on that. So just a second.
Yeah.
Okay. Yeah, so basically that is what I commented already. And the most important thing evolved around the high-risk AI. So let's take a look at that, because that will also be relevant for all the discussions we will have today. And of course, I will prepare the slides and we can send them to everybody afterwards.
Thanks.
So what is high-risk AI? This slide shows the... Okay, now it's better. You can see it better. So this slide shows what the EU defines as high-risk AI. And basically, we have two different options, paragraph 1 on the left-hand side and paragraph 2 on the right-hand side. Sorry for the misspelling. On the right-hand side, it's supposed to be paragraph 2, of course. So when looking at paragraph 1, basically, it's just a link to Annex 2. And so the AI access, the different topics that are listed in Annex 2 are considered high-risk AI. So we will look into that. And for paragraph 2, it says, again, a link to Annex 3. And in Annex 3, it has some information and says for some certain areas, for example, in general education, employment, so any HR things, critical infrastructures, which will be the most interesting thing regarding to space. There, for some cases, it's possible to have high-risk AI. So that was the short introduction. So the short answer basically on what the question high-risk AI is that it's defined in Annex 2 and Annex 3. And in Annex 2, there is a list of different EU regulations. And here I wrote down 2 of the regulations which may be relevant for space, but I think it shows that in most cases they won't be relevant for space. And if these 2 regulations are not applicable for space companies, then there is no link in Annex 2 saying that anything that has to do with space is considered high-risk AI. There might be written down something in Annex 3, of course, but for Annex 2, regarding these product safety regulations, there we don't really have a link to the space. It's referring to aircrafts, so any drones are mentioned with the unmanned aircrafts, but spaceships aren't mentioned, and also civil aviation security. That also doesn't really relate to the space aviation or to the space security. So to sum that up, in my opinion, there's no link in Annex 2 saying that any space company has to or is falling under the rules of high-risk AI. And therefore, we need to look into Annex 3. And here in Annex 3, basically, the most important thing might be critical infrastructures. And if we take a closer look into that, for example, the definition in Article 3, number 62, it has quite a lot of definitions. It says that AI systems used as security components, but only in the following areas. And here again, we have air transportation mentioned, but space is not mentioned. In some cases, we might have the critical digital infrastructure, but that is also providers of cloud. or which might be relevant in some few cases, public electronic communication networks or publicly available electronic communication services. So here we have some link to the space area. So that was basically the long answer. What is high risk AI, or what may be considered high risk AI within the space industry?
So if it's considered that there's no is there no high risk AI envisaged in the sector? If not, how will this impact? How will this act impact on the industry? I guess there are other areas where there may be some impact, and what will companies be required to do in that case?
Mm. Well, I think that for the typical space business, it won't really have a large impact. It will only have an impact if, depending on the tasks you will perform or the companies will perform, and there might be cases which fall under the area of critical infrastructure, and then it might have an impact. But in most cases, the impact will be only in cases like of administration. So in the HR area, just if you want to decide on possible new employees by the AI, so if you want an AI system to decide whether to employ somebody or not, that is something that will be considered high-risk AI. But of course, that won't be something particular to the space industry, but that will be relevant for all industries.
Well, okay, but it still affects the companies, so it's still relevant for the companies in the sector, even if it applies to all companies. But you say that's high risk in terms of employment, in terms of meeting employment conditions?
Yeah, the employment, let me go back to slides to show it here on the right-hand side. So employment in general is listed in Annex 3. So it might be applicable to high-risk AI, but basically not all AI that is used within HR department is considered high-risk AI. But the Annex states only some particular parts within the HR administration. For example, the decision whether somebody will be employed or will be fired. That is some examples in the HR area.
Okay, so the different risk profiles, but if a company is using AI in some of its operations, what are the obligations that it will need to do? That it needs to show that it's not high risk, or are there likely to be obligations that are placed upon the companies?
Allow me to show another slide just to summarize it and to give some more information. So basically what you can see below these 5 points, these are obligations for high-risk AI. And these might look as to be not to be so much obligations, but if you look into detail, it will be quite a lot that you have to consider. But one important thing is that the providers of the high-risk AI systems need to fulfill these obligations. So basically, if you mentioned Google already, if Google supplies an AI system, which is the provider, and you will be sort of the user or deployer, as it is named in the AI Act. So as a deployer, you do not have all these obligations. You just have to make sure that the provider of the AI is fulfilling these obligations. And the provider, for example, needs to carry out a conformity assessment, needs to ensure to get the CE certification for the AI, needs to register it with the new AI office, and to have different management systems like documentation on the risk, documentation on the quality of the system, post-market surveillance. So there are different obligations that the provider have as documentation obligations, but also these conformity assessments.
Okay. If we could perhaps, so if I consider two situations, one where a company is using some form of AI as an image interpretation tool, but is then selling the service, or another one which is actually selling the tool to the customer as part of a piece of infrastructure, hardware software that's being sold. Is there an obligation on the company in either of those situations?
Sorry, could you rephrase the question?
Well, yes, I'm trying to dig a little bit deeper into the question of the use of AI in image interpretation. So a lot of the companies are looking at this, and there may be a difference between AI sort of in a processing chain on the ground or on the satellite. We can dig a bit deeper there, but thinking of a company using an AI tool as part of its processing chain on the data on the ground. It can either be selling the processing chain to a customer, or it can be selling a service based upon the processing chain. Is there a difference in terms of the treatment of the AI under those conditions? Because I think you said just now that if the company is selling an AI tool, then there's a difference than if they're simply using it. Maybe I misunderstood.
No, exactly. That was the perfect summary. I think that, yeah, you summarized it perfectly. So if you only use software that somebody else applied, and if you use some software for image interpretation, then you will not have this full range of obligations. So if we are talking about high-risk AI. But you only need to check whether the provider of the AI system or the provider of the software to you has complied with these information or with these obligations. And yeah, so I think that brings us back to the question, what is high-risk AI, or when is it considered high-risk AI, especially for image interpretation parts? I think judging from the definitions of the AI Act, most cases of image interpretation will not be considered high-risk AI. And because if you have some satellite images that are not like, I mean, they are not like drones that can fly in a street and have some biometric identification, like with a live video or any camera that is installed somewhere, any CCTV camera that does some biometric identification of persons. That would fall under the AI Act. So for most of the cases of the Earth observation area, it will not fall under the high risk part.
Okay. Now, I mean, if looking at your full presentation, I think you made the statement that military applications are excluded, but some of the services are used for emergency operations or for situations where maybe there is a risk, there is a human risk, a life risk. Does that change the situation regarding the use of AI in the image interpretation? Is there an obligation that's met at that point? Sorry if I'm going back over various points.
No, sure. That makes sense. I think I can see from the chat that you are addressing the questions that are raised in the chat already. So I think there it really depends on whether it may be part of Annex 3. So Annex 2 does not apply in these cases. And for Annex 3, we can see on the right-hand side, and for example, when supplying public services, then it might be a case, or in case of border controls. But besides that, if it's not considered critical infrastructure, then it won't fall under the high-risk AI obligations.
Public services is a very broad category. Okay.
Yes, but we would need to look into the annex and check which parts of public services are mentioned there.
Okay, so Emmanuel Mondon is digging further into that same direction. We had a long discussion earlier about how, leaving aside the application, we'll come back to that, and I'll ask Emmanuel to come in a moment. But we had a long discussion. You know, a company could be using, to use the old terminology, a neural network or some package as part of its operational processing chain. How's it defined as being AI? What defines such a tool being used as being an AI tool? At what point does it consider to be artificially intelligent?
Mm-hmm. Let me get back to one slide, which is showing the definition. I think you are asking like the most difficult question regarding the AI Act. It was in the last years, the political discussions were mostly about questions like what is forbidden AI, how should we implement general AI, general purpose AI models, and these were things that were discussed a lot. It wasn't really discussed a lot how the definition should look like. I think most lawyers which were interested in AI, they were digging into the definition, and especially the commission draft at the beginning, there the definition was so broad that basically every software was considered AI. And they did some small changes to the definition, and so the final result we can see here. And so I just want to stress some of the most important aspects. So basically a machine-based system, that's pretty clear. Varying levels of autonomy, that I think is one of the parts to state, with a focus on AI, and inferring from an input it receives. I mean, we could talk some hours about that definition, but in general, I think it's clear that any Excel sheet is not considered AI, that it would have been considered under the EU Commission's definition, but now we can say Excel files or any operations within the Excel files are not AI. So that might be a positive news already. But of course, so we need the data to infer and to have varying levels of autonomy. So that was the broad answer to your question. And to go more into detail, I think it's really not so easy to answer. I think the definition still is pretty broad, and so we can expect a lot of software to be considered AI. And then we have the question again, is it high risk or not? And in my opinion, in most cases, it won't be high risk. So basically, you only have the obligation for transparency in some cases, and for AI literacy, for all the stuff. So I think even if the definition is pretty broad and most software might be considered AI, then still it won't be too bad, because in most cases there won't be too many obligations.
I mean, I guess it's sort of implicit if something goes wrong, But of course, then it's a question of avoiding the risk to exposure of something going wrong. This seems to me to have enormous potential for legal arguments and good business for you lawyers.
Yeah, that's one of the positive aspects.
Okay.
No, I'm kidding. But maybe it will be interesting to see how the marketing of software companies will change. So in the last years,
Yeah.
I think every company said now we use AI tools. And now with the new AI Act, once it applies, maybe we can see that less companies will say they're using AI.
Yes, yes, that's possible, isn't it? Yeah, there seems a lot of work to do to clarify that definition. Emmanuel's put a couple of points. He firstly wanted to explore about GNSS, but then has put a further question in the chat. Emmanuel, come and join us.
Yes, good afternoon. Thanks, Jeff. Speaking about fundamental rights, which are part of the risk mentioned in the paragraph 2. For me, location of someone is a personal data. It's about privacy, and therefore there could be an impact on the fundamental rights. So it means whatever we are developing, having a location component, could fall under this risk part. Is it the right understanding?
Yeah, thank you. I already read that comment on the chat. So first, maybe it's great to see that you were at the Alpine Privacy Days. Please say hi to Lucas from me if you are still there. Regarding your question, what part exactly are you referring to? So are you referring to one of the definitions in Annex 3 or?
No. So you have Annex 3 plus risk to health, safety, and fundamental rights. So for me, tracking a location of someone could be a risk related to fundamental rights.
Yes, I agree regarding this part, risk to fundamental rights. But it's my understanding of paragraph 2 that still you need to have any obligation or any part listed in Annex 3. And
it's 3 plus. Okay. It's not or.
Yeah, exactly. It's it has to be listed in Annex 3. So one of the parts written here on the slide, and then additionally, it needs to have this risk to fundamental rights.
But we're still talking about GNSS rather than imaging applications. I know sometimes they get quite close. Do you want to pursue your other point, Emmanuel?
Yeah. So indeed, I'm still at the Alpine Privacy Days today and tomorrow. And this morning, a German lawyer made a workshop dedicated to AI, and he was super conscious about the level of effort needed related to AI risk assessment. And he made it clear only the big 4 plus maybe the next 10 could achieve this. So my question is, do you foresee AI risk assessment for EO companies? Because if it's the case, we should all know that it's super expensive, time consuming, and very few stakeholders are able to do
it. Okay, so of course I don't know what Peter said exactly, I trust Peter. He's a great lawyer, and we are discussing different topics. I think for the AI risk assessment, you have to decide whether it's something that's necessary according to the AI Act, and on the other hand, something that you just want to do to ensure that everything is compliant. And from my understanding of the AI Act, you have the risk assessment obligation only in very limited cases. So basically, when you are a deployer of AI systems with high risk, then it might make sense to check the risk assessment of the companies supplying the AI, and maybe you want to carry out your own risk assessment. But if it's not high-risk AI under the AI Act, then at least there's no particular legal obligations under the AI Act. Then you might say, okay, due to privacy reasons or data protection reasons, I want to carry out such a risk assessment, but it would not be something that is defined by the AI Act.
But it seems like a risk to me, given the uncertainty about really what is an AI tool, what the definition is, given that at least some of the applications are used in critical situations. It seems to me there's a risk that companies would be sort of obliged for their own risk to perform a risk assessment in order to be certain that they're not falling foul of the Act. I mean, maybe this is something that will become clearer before the Act is actually implemented, but it seems to me that there's a risk there at this stage. You agree?
Yeah, sure. There's always a risk.
Okay, yeah, fair enough.
If I can have a follow-up point, Jeff, let's take an example which I'm currently inventing. A customer is asking me to monitor critical infrastructure such as harbors and or ports using Pictera. Is it under this paragraph 2? So it's about critical infrastructure, harbor or port or airport. I'm using a third-party provider, Pictera framework. So how can I make sure that I should do or not whatever is required in the AI Act?
Well, the part of the AI Act depends on the question whether you are considered basically the provider of AI or just a deployer of the AI. And if you are monitoring critical infrastructure using AI, then it might be a case that it falls under the definition of high-risk AI, and then you would need to get these clarifications from the provider of the AI system.
Yeah. So it's not. I would say it's not far away from us. Huh? The example I just gave, it's not super exotic. So, in other words, we should be super careful. We loved GDPR. I think with the AI Act, it's the next level.
Yeah. It all depends how you apply this Annex 3, isn't it? And whether you the interpretation, but as I said earlier, I think that companies will probably just as with GDPR, everybody played safe. everybody sort of tried to make sure that they met, even if the situations were not really very risky or threatening. So it seems a risk. Maybe we'll see some change. Wolfhardt's pursuing a bit the same line. Wolfhard, do you want to come and add to the discussion?
Yeah, it's basically. Sorry, I have to turn my camera off, and I hope you can even hear me because
We
I'm
hear you.
experiencing
Yeah.
bandwidth problems at the moment. So I stay off camera here. Oh, I could try. Let's give it a try. What I'm interested in is to know. Well, okay, 2 points. A, what is happening if a company, that's what I didn't ask in the chat here, what happens if a company is developing their own systems that could, and that's a question, do they could fall under the AI Act, like not traditional machine learning or traditional neural network technologies, but advanced expert systems that are rule-based, that are knowledge-based, that are traceable in their decision making, but at the same time highly complex and could become highly autonomous. Is this covered? And what then happens if a company uses their own, so to speak, in-house developed AI to provide services from Earth observation data, drawing information from multiple sources, multiple sensors, Earth observation, even ground-borne sensors, and turns those into a prediction service? I could see two risk areas here. A, is this a high-risk AI that they produce if they provide these kind of risk services, for instance, to disaster response forces or to insurance companies that react on it? So is this then automatically considered a high-risk AI? And then the other question, of course, is who is liable? What's the liability chain of command or chain of decision once this information gets applied by an insurance company who could say, okay, well, you developed your own AI. Well, yeah, how can we trust this? Is this certified? Is it not certified? And we made the wrong decision. Now you guys are liable. There's quite a complex series of questions attached to this.
Is that changed by having AI on board? Is the company not already liable for the information service? It was some.
Well, I think that's a general question I would have to for BHO legal. On top of it, to what extent is a company liable? I have to admit, we are approaching exactly this case at the moment with a client of ours. Is a company liable for the prediction that they are producing from EO and that they are handing over to an insurance company? Are they liable, or can they get out of liability if, in case this prediction appears to be wrong?
Yeah. Well, of course, no? Generally you can. What we have as a very long-standing discussion, and it's still the practice in the Earth observation and also geospatial industry overall. If you look to service terms, data licenses, be it public, be it private, all over, we still see extreme far-going warranty and liability exclusions. No? That's a rule even for Copernicus, etc. If you look to the Copernicus decisions, no warranty, no liability. And that is still the practice in the industry. Of course, no, you can always ask the question, are these far-reaching exclusions really valid? But as we don't have a lot or almost no court cases on these type of matters, well, it still works. No, everybody relies that you and all the other participants, all these exclusions are somewhat recognized. No, and in the practical sense, they are. From our legal standpoint, we would have said already since years that the more far-going they are, the higher is the risk that the clauses would not really stand in a real dispute case, especially as many players without much thinking, copy-paste exclusions which are more from US Anglo-American law, where you have also broader possibilities of excluding contractual liability. In general, these type of Anglo-American clauses, probably they would be all invalid if tested under a German court or French or Belgium or whatever continental European court. No? It's a general issue. I wouldn't say it's so much linked to the use of AI. What of course you said, no, as long as then it's all traceable, no? So that you can verify how the AI was programmed and how it worked and how it influenced the result. Of course, you are still fine. What Jeff and we already had as a kind of a pre-discussion, but that goes out of the AI Act questions itself, no? Is, while if you use AI, which is not so much traceable, how it plays on the trustworthiness of the data you provide, yeah, on the reliability, on the trust in its accuracy. And the more you sell your data or services to entities which then use it in, let's say, in whatever type of procedures, no? Court procedure, administrative sanctions, and for law enforcement, but also in insurance claims, no? In insurance claims as well. While your users, your clients, they need to rely on the trustworthiness, accuracy of the data. And how can you demonstrate it if there is AI which does something which nobody knows and nobody can verify? No, that's maybe still a bit in the future, but these are certainly questions. No?
Okay, thank you very much. That answers most of my questions. So basically, it means there are two cases. I have a AI, which, well, let's call it true AI because it's really intelligent. It's rule based. It's knowledge based. It acts logically thinking and deciding person. And then you have an AI which is, should I say, simple machine learning, training by doing, and is not traceable. And you basically cannot make a machine liable yet for what it's doing. Is that what I can take away from it?
Sure. Yeah, sure. No? Also whether it's your own product or whether you buy it in the market, if you use it for the production or value adding of your data and for your service provision towards your customers, in the end, while you have the contractual responsibility towards your customer. Yeah. So
okay, thank you.
Yeah.
Will the EU AI, my final question, my EU AI Act become more specific on these cases, on these instances? Is this kind of a working process, or are we living now with an EU AI Act that is basically firm and will not be revised for the next couple of years?
No, it will. The text will remain as it is. There will be some clarifications by the EU Commission. So there are some rules within the AI Act saying that the Commission should give some more information. And also there's the new AI office that was established last month. And they will also give some more information on the interpretation of it. But basically, we will have to live with it in the next years, and then we will see what happens or how the interpretation will work out in the EU.
Okay, a classic legal practice for you guys. You now have an act, and the interpretation and the comment document will then specify further.
Yes,
Yeah.
exactly.
Thanks.
Yeah.
But I think,
thank you.
Yeah, Ingo?
Yeah, also
typically,
typically the Commission would come over time up with implementing acts, no? And so building upon the core legislation, that then there would be a specific further legislation and and also other instances. So it will, even if the act as such will stand for some while, it's certainly AI, as AI is evolving fastly, there will be also legislative work or regulatory work on these matters. Maybe a question, Matthias, or something. Larger clients of us, they are working already on internal guidelines. What employees are allowed to do, what they are not allowed to do. So this is something which, of course, also the Earth observation industry should consider in dealing with the data, but also for other activities. The Earth observation industry is also very active in research and in publications of papers and so on. So you have also employees using ChatGPT for doing their academic publications and so on. So at least for a bit larger companies, that could be also something to be explored, whether to do something like internal rules and procedures.
Yeah, that's an interesting angle. What when's it likely to come into force? What's the timing?
Let me show another slide on that. Yeah, here it is. So that I think will give you a good overview, and maybe I can also get back again on what we discussed right now. But basically, we will have to wait for the publication in the official journal. That will probably happen in May, April or May. Let's see. And then some parts will be applicable in 6 months. So especially the unacceptable risk part, so the like the forbidden AI, that will take place pretty soon. But besides that, the general purpose AI models, which I think aren't really relevant for what we are talking today, these rules will apply in 12 months, and then the most important thing, the high-risk AI obligations will even apply in 3 years. So that is quite a while to prepare. Since the question was asked already, how to clarify everything, and so I think in these 3 years a lot will happen, and there will be a lot of clarity on what will fall under the high-risk AI definition. And the other part, which is a bit weird in my opinion, is that it will be a 2-year period for the transparency obligations, which are here in yellow, and the AI literacy obligations, which are green. So basically, as I said in the beginning, it will be relevant for every company. So basically for everybody working in companies listening today, it will be relevant when using AI systems. So basically everybody now, then you have to ensure AI literacy, so to be that all the relevant staff is informed about AI. And I think in most cases, this AI literacy exists already. So if you are working with AI tools and using them for the business, then the people working with the tools, they have the information already and they know about risks. So it's a bit weird that you still have 2 years to ensure that everybody has some literacy on AI. But yeah, so to sum it up, only the forbidden AI will be applicable pretty soon. And for all other parts, there is quite a while to adopt to the new obligations.
Okay. You mentioned earlier about sort of preparing internal guidelines. Is there anything else companies should be thinking of doing in preparation for this coming into force?
Yeah, so I think the most important thing will be to check whether companies are using with forbidden AI. So that might be the case when doing biometrical analysis on a live basis, for example, then it will be forbidden. But for most of in the Earth observation area, it will not be forbidden AI. So right now there's not much to do regarding the AI Act. I think it makes sense to wait a bit, but what you can do already, which makes sense even without the AI Act, just to check what AI tools are you using already, and then to check whether it might fall under the high risk AI area, and then be prepared for the obligations. But besides that, the most important thing right now is just to check just with all software you are using, whether it's compliant with laws, whether it's compliant with data protection law, and these things. And I think right now these are the most important aspects. And regarding the AI Act, there's enough time in the next 2 or 3 years to prepare.
Okay, thanks. Well, I mean, I'm sure it's a subject we'll come back to again. As this progresses, maybe we'll need to readdress also the sort of the legal implications, the regulatory environment, and whether companies are at risk. It's certainly not going to be a subject to go away. That's for sure. Matthias, thank you very much for helping us to understand what's going on and helping to shed some light on the Act, the AI Act, as it will come in. It's been a pleasure talking with you, and I hope we can talk again soon, and indeed Ingo. So that's it for this week. Thank you all also for joining us. Ongoing reminder for the industry survey: if you haven't completed it, then please do complete it. It really is important to have that information. So please be ready and do it tonight. Do it now whilst it's fresh. And then in 2 weeks' time, yeah. So as you know, ERSC has had a working group looking at the EUDR. A lot of discussions with the Commission. And for the next EOcafe, we'll have a real expert in forest certification coming from PEFC International. There are, I think it's 2 main certification bodies for timber, looking at sustainability and whether the timber is coming from sustainable sources. So we'll have a talk with Rob Shaw and Lucien Feligene in 2 weeks' time. So that should also be I think a very relevant and interesting subject. So hope to see you then. As usual, please, you can stay along. We turn off the microphone, the recording. Not the microphone. We turn off the recording, and you can just open your microphone and join in the conversation if you wish. So a final thanks to Matthias, and everybody. See you in 2 weeks' time.